Perjury goes. That's a felony. Perjury is a felony. So here Madison is clearly saying, Hamilton said it in 28, not as well, that we have these dual governments. In fact, I'd encourage you to get a copy of Sheriff Mack's Victory for State Sovereignty. Let me give you a little summary about this and then I'll go forward. This is a summary of Sheriff Richard Mack's case against the Brady Bill. In 1994, the federal government passed the Brady Bill and it required the state chief law enforcement officers to enforce and collect the funds and enforce the law, collect the names of gun owners, purchasers. Sheriff Mack said, no, I'm not doing that. He was the only one of the 15 sheriffs, 12 of whom were in the meeting at the time. He said, I'm not going to do that, and he stood up. Eventually, Sheriff Prinz up in Montana joined him, and then 5 additional sheriffs eventually, out of the 3,141 sheriffs in America, 7 sheriffs said no. Mack decided to take it on. Actually, the National Rifle Association offered their support, and they went forward with a 10th Amendment case. He decided to have his own lawyer. He spent about $350,000 of his own money. He took it to the United States Supreme Court, and Justice Scalia wrote the opinion of a 5-4 decision, and it's powerful. And I would recommend that each one of you get a copy of this. Let me read this summary of the holding. It's instructive and it's relevant to what we're talking about. Order of the court. We held in New York, that was a 1992 Supreme Court case, that Congress cannot compel the states to enact or enforce a federal regulatory program. How many of you knew that? Very few. Listen on. Today we hold that Congress cannot circumvent that prohibition by conscripting the state's officers directly. The federal government may neither issue directives requiring the states to address particular problems, nor command the state's officers or those of their political subdivisions. What does that mean? School boards?
Yep.
Townships? Counties? Or their political subdivisions to administer or enforce a federal regulatory program. It matters not whether policy making is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. What did Madison say? Compound republic, dual sovereignty of the states and the federal government. That sovereignty actually is ours, we just let them use it. What did the dissenting opinion, the 4 justices on the left, say? This was written by Stevens. It says, if Congress believes such a statute, that's the Brady Bill, will benefit the people of the nation and serves an interest of cooperative federalism better than an enlarged federal bureaucracy, we should respect both a policy judgment and its appraisal of its constitutional powers. Punt, right? In other words, we aren't going to get involved with this, and we're going to say the federal government shouldn't be messing with this, and it's constitutional. What did Scalia say about this brainwave from the dissenting opinion? He said, it's empty, formalistic reasoning of the highest order. Memorize that. You can use that a lot. Empty, formalistic reasoning of the highest order. In other words, you've got to be kidding. That's a nice way of saying it. I'd encourage you to get this, $2 down there at the tent. So what we have is this understanding that we have a relationship between the states, which came first, and are superior to the federal government. And if the federal government usurps its authority, the states have the responsibility and the duty to say no. That's called nullification. How many of you heard about that before? Great. Have you read Thomas E. Wood Jr.'s book on nullification?
Yep.
I heard a yes.
Yep.
Great. 2010, nullification, how to resist federal tyranny in the 21st century. Thomas E. Wood Jr. He is Harvard graduate, economics, history, brilliant, funny man actually. If you had never heard him, you can get on our website and they've got a whole page of sites that you can go and listen to, like 10 minutes to 2.5 hours or something like that, whatever you want to spend the time, but he's very, very good. This book is excellent, and it proves without any doubt that the framers, Jefferson, Madison particularly, understood that the state governments have the duty to interpose, is what Madison said, when the federal government usurps authority. Absolutely proven over and over with extensive documentation, and it's very well supported by an appendix. So when somebody says that nullification doesn't work, I can tell you that it does, because we fought the Real ID Act. How many of you know about that? 2005, everybody's going to get a uniform license, driver's license, or some ID sanctioned by the government, right? It's all going to be controlled. Everybody in the whole country will have the same thing. Well, we in Pennsylvania fought that. Took us 5.5 years, 3 sessions to finally get both houses and the governor to sign it. Now they gutted the bill, but it was truly, and is truly, a nullification bill. Another one that's up right now, which I encourage you to think about, is House Bill 357. How many of you heard about that? Got one or two. In essence, it's a one-page nullification bill that says any new law from the federal government respecting guns or ammunition or magazines will not be enforced in Pennsylvania. And if the feds come in here and try to enforce it, that's a felony. Guess what? You're going to be arrested and prosecuted. Now, that's not going anywhere, unfortunately, because nobody's pushing it other than a few. And the chairman of the Judiciary Committee doesn't like Darrell Metcalf, and he doesn't like the bill, so we need to work on that. It's something you want to do. Now, whether that passes or not, does it matter? Article 1, Section 21 of the Pennsylvania Constitution says what? Says the right of the citizen to bear arms in defense of themselves and the state shall not be questioned. I have a paper that says shall not be questioned means exactly what it says. It's one of the 6 papers on the website about the right to bear arms. And I would ask you a question. How many of you have a right to carry? It's actually a license, isn't it? All right. Is it for concealed weapons? Is it a permit or is it a license? Read it. It says it's a license to carry. It has nothing to do about concealed, but that's what they sell it on. Because this is an open carry state, isn't it? That means anywhere except in Philadelphia and I guess Pittsburgh, you can strap on a weapon on your hip and walk anywhere you want. Now, some people say, well, you go into a business and they object, and they have a right to do that. And what you do is you leave. That's the thing to do. And then if you don't, they can have you arrested for disturbing the peace. That's what they think they can do. But hey, that's questioning it, isn't it? So the government has no authority to come in and intercede, but the owner of the business does, because it's a private business. So the point being is the law is very clear. I would ask people to consider, do you think the framers, both the state constitution in 1776 and the federal government in 1789, and therefore in 91 when the Bill of Rights was ratified in the Second Amendment, do you think they cared whether the gun was under your blouse or over, your jacket? No, of course not. They didn't care, and they wrote it, and that's what they meant. You can have it, and it's your right, and it shan't be infringed at the federal jurisdictions, and it can't be questioned in the state jurisdiction, and Ohio's constitution is very much the same. So the point is, why are we subject to all these gun control laws? Could you tell me why? Every one of them questions your right to bear arms, don't they? They're unconstitutional. You can figure that out. That's just plain English. In fact, in the paper, The Right to Bear Arms is a God-given right, where Scalia said to Mike Wallace, he said, well, they were talking about Obamacare, but then he got on the right to bear arms, and he said, well, you can have a gun that you can carry. You can't have a tank, and we'll have to deal with these shoulder-mounted rockets when it comes in front of us. I always thought that Scalia was an original tent guy. Clearly he's not. He's a textualist. He's confirmed me of that. But the point is, you can have any weapon that the government has, can't you?
That's right.
Why are those provisions in the constitutions? To make sure that we can protect ourselves and the state or our family against government usurpation. Just like England was doing when it told those in America, you got to pay this tax, and they came in here and made sure you paid it, right? 1765, the Stamp Act. Point being is that sort of started the ball rolling, and it ended up in the War for Independence, and frankly, we separated from England, and here we go. The rest is history. The point being is, those provisions, like all other provisions in both constitutions, are put there for specific, well-defined reasons. And if the government has a weapon, how in the world are you going to go to a gunfight with a pair of scissors? Can you help me understand that? Oh, wait a minute, that's Homeland Security's suggestion, isn't it? Or was it Biden? I'm not sure who. No, he was the shotgun. Go out and shoot a couple of shots over New Jersey, which, by the way, will get you arrested. The point being is, that's ludicrous. The constitutions are there to tell the government, the particular government, state or federal or local, what they can do and what they can't do.
That's right.
That's all. And they don't operate on us. It's our instructions to those in government as to what they can do and what they can't do.
Absolutely.
What a great concept, right? Oh no, they're going to come around and tell you you can't have your grass any higher than this, and you got to paint your house a certain color, and you on and on. Zoning. How many of y'all like zoning? Not really? Oh, no? Nobody?
Nobody.
Well, but guess what? That's unconstitutional as well. So the point being is, we can learn this and be able to say to those in government, and this is what I'd suggest you do, you know, be courteous, be direct, be assertive, and say, would you please tell me in writing where your lawful constitutional authority is for you to ask me to do that or not to, or to not do something. Now, if you've got a rogue cop, he's not going to like that. And there are a lot of good policemen. They think they got more power than they do, but nevertheless, it's a tough job. But then nevertheless, if they ask you to do something, anybody in government that isn't authorized by the Constitution, they have no authority. They're outlaws. They're making you do something for which they have no authority. Now, when you do that, there's a risk, isn't there? So the best thing to do is get a whole lot of your friends around you that you can call and say, hey, I got somebody on my doorstep that wants me to do something that isn't lawful. Would you please come over here and witness it? Bring your cameras with you. And everybody's got a camera now. It's on your phone. So bring it. And guess what? When your neighbors show up, peacefully assemble, that's your right to do. Usually the police say, oh, maybe another day. All right? Not always. But if you have your friends with you, I can tell you going to prison, which by the way is a possibility, is a whole lot better than not having them there. So network with people who will be there to help you. And even if you get in trouble, if you need help with your house, where's the best place to go? Not to the government, not to go to the municipality and say, hey, we need an ordinance that'll make sure that my neighbor cuts his grass. All right? Why don't you go over and say, hey, I understand you have a problem with your mower. Maybe you need some help. Can I help you? All right? You can't do it there. Go to your community, go to the church. The last thing you want to do is go to government. Unfortunately, most people say, hey, we need a law. And they go and get it. And then you got government, who is always willing to do that, coming in and telling you what to do. Do we want that? No. But most people do it because we've been trained to do it. So the solution is to get those in the local government, in your township, in the county, to in fact repeal these things that they've done. In the county level, there are 2 Republicans or 2 Democrats. If it's a majority Republican county, it's 2 Republicans. If it's a majority Democrats voters, it's 2 Democrats. And then you have the minority, which is the 1, Republican or Democrat. All right? And then I tell folks, 2 beats 1 every time. If you get 2 county commissioners that will act constitutionally, only act constitutionally, first of all, your taxes are going to go way down. All right? And secondly, they're not going to be bothering you a lot. But you've got to have a sheriff in order to back it up. Or you've got to have a militia, that is organized citizens in the county, to say, we will in fact back the sheriff up, or we will take the lead in this. All right? So understand that that sheriff is the chief law enforcement officer in the county. Go down to the tent, get a copy of the paper. Sheriff, chief law enforcement officer in the county. All right? And he's the executive branch in the county, not the DA. He's the chief prosecutor, right? He's an officer of the judicial branch. He takes an oath to the Supreme Court. Article 5, Section 10C. Read it. It's in the state constitution. He is, in fact, an officer of the court, isn't he? He's an officer of, he's a lawyer. He's an officer of the law. He holds the office of attorney at law. Title 42, Section 2521. His oath is 2522. He pledges to the courts. He's working for the courts. Problem is, we think that he's there working for us. Well, he's not really. But the bottom is, in respect to this jurisdiction and authority, he is part of the judiciary branch, isn't he? The judicial branch. How in the world can he be in charge of the executive branch at the same time? Please help me understand that. And you go ask him, how can you do that? Well, they passed some sort of rule, or they passed some statute that says they can do that. They can't even arrest anybody. The DA cannot arrest anybody. How can he be a law enforcement officer? He's got to hire some investigators that have arrest power by legislation or rule. And here we have a government that no longer resembles a constitutional republic. That's why we're in trouble. And so what's the solution? Understand what's happened. Understand why it's supposed to be, not the way it is necessarily, although I think we pretty well understand how it is. And then insist that those in government follow their oath of office. Follow the law. Now, one of the things that is going around right now is having a convention of states. How many of you know about that? I guess I asked this question. How many of you are in favor of that?
No.
Got a good no over here.
No.
Okay. Well, like I said before, the last time we tried that in 1787, we got a new constitution, so you think about it. There's already been one written, folks. If you want to go from a possibility of saving this country to no hope, let that happen. All right? Putting aside Mark Levin's push for this, answer this question. If they're not following the current constitutions, what makes you think that they're going to follow, I don't know, 7, 11, 20, 100 new amendments? Can you help me understand that? They're not. They have no intention of following the Constitution, and the attorneys and judges say don't worry about it.
When they open it up, they can leave it open as long as they want and do whatever they want with it.
The comment is when they open it up, they can leave it open and do whatever they want. It's absolutely true. The answer to that is stop it. There are a lot of things going on that aren't legitimate, aren't lawful. I will make one comment. I won't elaborate on it. A wave that's going through, particularly out in the western part of Pennsylvania, is the National Liberty Alliance. If you're associated with the National Liberty Alliance or think that's a good idea, read my paper, National Liberty Alliance Plan, quote unquote, exposed. You type in National Liberty Alliance and you'll see National Liberty Alliance, and the next one under there is National Liberty Alliance exposed. It's getting a lot of hits. All right, in September 23rd, 2013, I wrote a paper after examining this, and it is a fraud, it's a scam, it is absolutely not going anywhere. If you believe in it, please read the documents for what they say. It will never work, it's not lawful, and I take from 24 years of experience of reading and writing and going to court. You judge whether it is or not, but you can look, this is not going anywhere, and those people who are involved with it open themselves up to serious, serious action by any lawful means, all right? Now you can say we got unlawful government and all that, but even in light of if we had a true government, they would be guilty of fraud. I'll leave it at that. I know that may be controversial, and that's okay. It's my duty to point out what I understand to be the law. I'm willing and able to support any lawful activity. In fact, if you read the Civil Action Plan, you'll see that the third part of that Civil Action Plan for the sheriff brigades and others is to have constitutional common law grand juries and trial juries, called petit juries, or petite, however you want to pronounce it. So that's always been part of my plan. But you got to have the people informed, organized, networked, and a sheriff, some way to enforce it before you start exposing people to these corrupt people in the courts, because guess what? The judge is going to pick up the phone and say, this guy just came in and threatened me. How about Officer so-and-so? Go arrest that person. All right, now they got to do something overt, like the people did in Dixie County, Florida, and guess what? The guy got arrested. Predictable, all right? He had a great opportunity. My paper on that will be out shortly, a missed opportunity in Dixie County, Florida. I won't go into that, but the point is, we need to follow the law, and I'm willing to support that, and anybody says that I'm against grand juries, wrong, okay? I am willing to discuss it at length with anybody. So what's this power that we have, the solution we have, that we can use right now and be effective? I categorize this as nullification. Nullification is simply saying no. Now, if you are an individual, how many parents do we have here? When your child was growing up, what was the first word that that child said to you, generally? Well, I know what our daughter said, no. Now, I know she learned it from her mother and me because we are the first child, only child, and we were very protected, so we said no a lot. They soak it in, and of course, when they got to be 2, man, you get it all back. Blank. You know, everything's no or why. And so the point being is, we've forgotten how to say no, haven't we? Now, a child says it because they don't want to do it. Well, we ought to be saying it because government's got no authority to make us do it. Now, you got to know what your rights are, and you got to be able to be informed and learn how to say no where they don't beat you up. But nevertheless, maybe getting beaten up is the thing that needs to happen. So that's individual nullification, isn't it? Saying to government, you have no authority to ask me to do it or not do something. If you think you do, prove it. Write it to me on a letterhead with a signature of somebody authorized or sign such a document with specific evidence as to what constitutional authority, lawful constitutional authority, because the Constitution's been changed unlawfully, that says that you have the authority to make me do that. Now, you can do it by any means that you can. Article 1, Section 7, again, I love the Constitution. Article 1, Section 7 of the Pennsylvania Constitution has to do with freedom of speech, press, and libel. That's the title. Get a copy. Now, this only has to do with ABC, NBC, Fox, all that, right? That's all the thing it has to do? That's the press, right? Wait a minute. What did the framers say? The printing press shall be free to every person, that's you and me, who may undertake to examine the proceedings of the legislature or any branch of government. And no law shall ever be made to restrain the right thereof. Did you know that? How many laws? Oh, well, this is only a free speech zone, right? You got to stay in this little area right here. That's the only place you can speak. No, anywhere you go is a free speech zone. That's what this says. And you have the duty and the right to examine what government does. It doesn't talk about me talking to you. It's when you're talking about government. How are you going to get government to change if you don't talk about it amongst ourselves and then say to government, wait a minute, you can't do that? All right? Do you think the framers didn't say anything to each other before they wrote the Declaration of Independence? Of course not. They met in a bar. That was a great thing, right? In a pub. Well, anyway. It goes on and says, the free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. Of course, you can't lie to somebody or tell somebody that they did something and get them in trouble, because guess what? You're wrong. And they always say you can't scream fire in a crowded theater unless there is a fire. Can you tell me how you're going to constrain somebody from doing that? Somebody stands up and says fire, what are you going to do? I mean, get out of there. But if there's not a fire, you have standing to sue that individual for false alarm and causing harm to you, and that's the remedy. When some attorney says you can't scream it, how are you going to stop somebody from screaming fire if they want to scream fire? You know, it's just stupid. But anyway, no conviction shall be had in any prosecution for the publication of papers related to an official conduct of officers or men in public capacity, or in any other matter proper for public investigation or information, where the facts that such publication was not maliciously nor negligently made shall be established to the satisfaction of the jury. In all indictments or libel, the jury shall have the right to determine the law and the facts under the direction of the court, as in other cases. That's our provision for the people in the jury to judge the law and the facts, and that's why in the House version the attorney said, well, no, that's unconstitutional. That's why they did that. Didn't care that I objected to it. Let me round this up by explaining about nullification in a broader sense. So individually, you have this right and a duty, all right? In the county level, how many of you heard about jury nullification? If you haven't, I think somebody has a booth here called the Fully Informed Jury Association, FIJA. Great source of information. But bottom line is, in Pennsylvania, you're entitled to judge the law and the facts, and in every case, you're entitled to a trial by jury. Every case. Now, they won't do it because it takes too long, costs too much, and the people don't know about the law anyway. That's what the attorneys are written. But, in fact, the jury is there as a community in your county. That's the only place that the people can come from, to judge the law, whether the law is valid, and whether the person who's accused has in fact violated the law that is valid, is constitutional. Now, there's a couple of really great examples. One of them, which ought to be near and dear to you, is William Penn in 1670. How many of you heard about the hat trial? Well, let me tell you, got one back there, that's good. What happened? William Penn was raised primarily in the country because his father was an admiral in the British Navy, and so he wasn't home very much, and so this young man was a little, shall I say, free-spirited. At any rate, he ended up being sent to a number of colleges in England, which he left, and then they sent him to France, and he came back and became a Quaker. He was a devout Quaker. His father was not happy, but nevertheless, that's what happened. And so one of the laws that was on the books at the time by the British government was that you could not publicly preach Quakerism or any other faith than the Anglican religion in England. And if you did that in public and convicted, you were subject for death. The penalty of doing that was death. Pretty serious crime, right? Well, Penn and Meade, being who they were, of course, went out and preached Quakerism in the streets of London. And they got arrested, thrown into jail, went on trial. Well, one of the things that Penn had learned when he was in France, a little bit of law, and so he decided to defend himself and Meade. And his father said, look, Junior, his father's name was William Penn too. I'm making that up, I don't know what he said. But the point being is, go in and behave yourself. Be respectful, take your hat off, and try to get yourself off. Well, that's what he did. Usually he wouldn't have done that, but he did. He went in and was very respectful. Immediately the judge ordered the bailiff, the tipstaff, to put his hat back on. And then he found him in contempt of having his hat on. Now, the people in the gallery, it became known as the hat trial, got very much involved and emotional, and they were supportive of Penn and Meade after that little incident. In essence, it was a Star Chambers. And here they are going through the process. And so the evidence was presented, and the jury came back. It was led actually by Edward Burchell, who was a rich merchant in England, had a fleet of ships. And he was the foreman of the jury, and they found him not guilty. And the judge said, that's not good enough. Go and deliberate more. And kept sending them back. And finally, Penn and Meade were thrown in jail too because they were disruptive. And eventually the judge threw the jury in jail. Because they didn't come back with what he wanted. Does that sound familiar? Nothing new under the sun. Anyway, so what happened? Eventually, 8 of the jurors acquiesced. The conditions were deplorable. 4 of them didn't. Burchell was one of them. And he said, my vote's not for sale. And so, came back. Eventually, the Queen interceded after 10 weeks, I think it was, a long time. no toilet facilities. Oh yeah, no tobacco. That was a bad thing. Anyway, the point being, it was very bad. And eventually the Queen interceded, and the not guilty plea was upheld. Now think about it, those of us who are Pennsylvanians, if Penn had lost, there'd be no Pennsylvania. He'd have been dead. He would not have inherited the land of Pennsylvania, well, actually it was part of it was Delaware, Maryland, and some of New York, would not have inherited that land. We wouldn't have a Pennsylvania. So, pretty important. So that's near and dear to Pennsylvanians. But what did we get out of this? His standing up, and Burchell and the 3 other jurors standing up. What did we get secured? We got, first of all, trial by jury, freedom of speech, freedom of assembly confirmed. We also got freedom of religion confirmed, and Penn had written a petition for writ of habeas corpus to get the jurors out of the jail, and so he had learned that in France, and so we have that secured again. Those very fundamental rights, which found their way into the Declaration of Rights of the laws agreed upon in England in 1682. Came here initially. You ought to read that document. Tremendous. And if you look at that, you'll see a lot of the things that are in the constitutions, ours particular in Pennsylvania, that came from those writings. All right? So we have that. We also have John Peter Zenger was a 1735 case in New York. Now Zenger was a printer, and he published statements written by someone else against the governor. There was a law that you couldn't do that. Now, that was before the Bill of Rights. So anyway, and so the Zenger was arrested and put on trial. His attorney argued that truth was a defense, and in 15 minutes the jury found Zenger not guilty. Even though he had printed it, it was against the law, but what he'd said was true. And so the jury found him not guilty. So there's 2 good examples. There are many others that I would encourage you to learn. So this right that's secured by the Constitution, state and federal, to have trial by jury, where the jury has the right to judge both the law and the facts, is absolutely fundamental to our system of jurisprudence.